Major breaking news out of the state of Texas. A federal district court judge, Judge Reed O'Connor, has entered an order enjoining the ATF from enforcing the pistol brace rule with respect to a series of individuals and companies. Among others, Firearms Policy Coalition, their members, Maxim Defense Industries, and their customers, as well as William Mock and Christopher Lewis and their family members. This is a big deal because Judge O'Connor, in ruling against the ATF, didn't just do it on procedural grounds under the Administrative Procedure Act, that geeky stuff involving exceeding authority for agencies. He actually entered an order in favor of, yes indeed, the Second Amendment's right to keep and bear arms. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners. Make sure you check it out, why I'm worried about what the anti-gunners are trying to do and why I have laid it all out for you so you know their battle plan and can help stop it. All right, folks. So we've talked a lot about pistol braces, and this is a big deal, what I'm about to tell you. This is a big deal. That is, we have a Second Amendment ruling in favor of individuals that have pistol braces. So I want to talk about this because this is something I predicted many months ago, that a pistol with a brace attached constitutes a short barrel rifle. But of course, a pistol on its own is clearly constitutionally protected because Heller said handguns in America are constitutionally protected under the Second Amendment. And a pistol is a handgun. Hello. So that's protected. And then we know rifles are protected, although the Supreme Court has not outright said it yet. That's what the AR-15 gun ban, assault weapon ban litigations are all about. But it's pretty clear that AR-15s are in common use by Americans for lawful purposes. So the question is, if you have long rifles are protected arms under the Second Amendment and handguns are protected arms under the Second Amendment, why wouldn't a gun in between a long barrel rifle and a handgun not also be protected? Like, what would make the middle round gun somehow different? No reason to think it would. And I'm happy to report, as I predicted many months ago, that we're now starting to see movement specifically in the Second Amendment space dealing with these short barrel rifles, also known as pistols with pistol braces. Now, what do I mean by this? The first round of litigations and battles involving the pistol brace rule dealt with very geeky the Administrative Procedural Act, which is a federal law that says that federal agencies are allowed to promulgate regulations, but they can only promulgate those regulations that are consistent with and within the scope of their enabling authority given to them by Congress. So Congress passes a statute that creates the ATF and gives the ATF certain authorities. Maybe it passes the Gun Control Act and gives the ATF certain authority to enforce it and so on. Those statutes enacted by our representatives in Congress, signed by the president, are statutes. Those statutes give agencies, whether it be the FDA, the CIA, the FBI, the ATF, whatever, gives them authority. Part of that authority usually involves the ability to issue regulations that are supposed to help clarify or for good housekeeping purposes, parts of the law. Now, what the ATF has done under Joe Biden is they have simply decided to go rogue, as I see it, and take advantage of the Obama statement that says, oh, hey, I'm president, I can govern with a pen and a phone, And that's what Joe Biden has done. He's basically had the ATF, by virtue of using these regulations they promulgated, rewrite American gun law in a way they can never have enacted it through Congress. So now the fight in the courts is, are these regulations, for example, extending the scope of what a firearm is, a short barrel rifle, to pistols with is now a pistol with a stabilizing brace together, somehow now an NFA item, thus you have to register it under the NFA as a short barrel rifle? These kinds of questions. None of this was done by Congress. This is all done by the ATF. So the first round of litigations have been whether or not the ATF, in promulgating these regulations involving pistol stabilizing braces, converting them effectively, as by the ATF's definition at least, into short barrel rifles. And thus you have to register them under the NFA, according to the ATF arguments. So the question, the first round of questions is this legal under the Administrative Procedural Act that says that if a agency exceeds its authority in rulemaking, the rules that it promulgates that are in excess of its statutory authority given to it by Congress are null and void. They are what is known as to be vacated, or the remedy of vacatur, which we've talked about in other contexts. Now, that's where the first round lied, okay? But now we're starting to see the second wave attack on these rogue ATF rules involving various things, such as pistol braces. And of course, you all know there's fights involving the ghost gun regulation of frames and receivers, but today we're talking about the pistol braces because there was a major victory in Texas in the United States District Court for the Northern District of Texas in the case of Mock versus Garland, where the Firearms Policy Coalition had a huge win, and they didn't just win it on the APA grounds, arguing that it was excessive, that the ATF took excessive authority they weren't entitled to. They've now won it, hugely so, on Second Amendment grounds. They have now created extra powerful precedent in favor of the Second Amendment's right to keep and bear arms. And that's what I want to talk about today. Specifically, what happened here was in its first iteration of Mock versus Garland, which was a challenge to the pistol brace rules. What happened was the district court judge says, nah, I don't think there's a violation here under the APA. I'm not going to enjoin it. The FPC, Firearms Policy Coalition, took an immediate appeal to the Fifth Circuit, and the Fifth Circuit ruled in favor, as well they should have, of saying that the ATF had exceeded authority and that it looks like an injunction should be entered. And they sent it back down to Judge Reed O'Connor, asking him to complete the task of going through the 4 factors of a preliminary injunction. You know the 4 factors, we talked about them before, that the plaintiff, the Second Amendment plaintiff, A, has a right, is likely to succeed on the merits, B, that the balance of the equities are in favor of the plaintiff, that the balance of that there's public interest involved, and that you have what's known as irreparable harm, and getting arrested and going to jail is irreparable harm, and losing your fundamental constitutional rights is irreparable harm. So once you win, you're likely to win on the merits of a Second Amendment claim. You basically fill in the blanks, and you've won the other 3, the additional 3 elements there to satisfy the burden that you have to meet to have a preliminary injunction. So again, the Fifth Circuit Court of Appeals sent the case back down after saying that, yeah, this doesn't look right to us as a matter of administrative procedural law. So realistically, it looks like ATF's going to lose, but we're going to send it back down to Judge O'Connor and let him do some further work. So what Judge O'Connor did is he had additional briefing from the Firearms Policy Coalition plaintiffs and also got some additional briefing from the government, the Department of Justice, ATF, and he just issued his ruling, and it's very powerful. Now, he already said, of course, that the government had exceeded its authority under the Administrative Procedure Act, but Judge O'Connor then went on to talk about the validity and the likelihood of success, which he said there was a likelihood of success, that the Firearms Policy Coalition plaintiffs, including William Mock, would indeed win on their Second Amendment claims. And those claims were basically saying, as we've talked about before, that these pistols with stabilizing braces are indeed protected arms under the Second Amendment, which is the text of the Second Amendment, because an arm is anything that can be used offensively or defensively. Anything that can be used offensively or defensively, including body armor, is an arm, textually. That's important, because once you satisfy the text of the Second Amendment, which they clearly did here, because a pistol with a pistol brace is obviously an arm because it's a pistol. So textually, it's an arm, which means what? You know what I'm about to say. Whether it's under the Heller methodology or the Bruin methodology, which is the same interpretation method of interpreting the Second Amendment, once the text is satisfied and a modern-day gun control law touches fingers with or implicates the text of the Second Amendment, which it does here because this is essentially restricting or putting restraints upon a particular type of arm, the burden shifts to the government to justify its modern-day gun control law using history. Now, when you're dealing with a gun ban case, which is the Heller approach, we know the answer. You don't have to go back and do all that hooey and analyze all these historical analogs. That's a mistake. You don't need to do that. Why? Because the Heller Supreme Court already did that. They analyzed all the potential historical analog laws that could potentially restrict the right to possess an arm in American life. And they concluded that no matter what else you can say, no matter what else you want to say, no matter what else your standards are, at a minimum, if an arm is in common use by Americans for lawful purposes, it cannot be banned. But the in common use question, and this is very important, we've talked about this before, and then we're going to go back to what Judge O'Connor did here in the mock case, which he got right. Once the text is implicated, the burden shifts to the government. The government has the burden of proof to show under Heller, because you're dealing with an arms ban case, the government has to show that a particular type of arm is not in common use by Americans for lawful purposes. So here, because a pistol with a pistol brace is indeed an arm, that's a no-brainer, it's obviously an arm, the burden shifts to the government, and because it's an arms ban case, as opposed to some other Second Amendment issue like sensitive places, 18 to 20-year-olds, can they have guns, things like that, licensing rules and restrictions, those might require an additional analysis of historical analogs, but you don't need to do that when you're dealing with an arms ban case, which this effectively is, because they're saying you're going to lose your pistol with an arms brace. But because it's an arms ban case, if it's in common use, it cannot be banned, because if it's in common use and cannot be banned, the reason why it cannot be banned is if it's in common use by Americans, it is not what is known as dangerous and unusual. Now, the concept of dangerous and unusual is a historical concept that there is some evidence in American history, really the only evidence of a possible gun ban argument at all, is that if an arm is dangerous and unusual, it cannot be banned. Now, as to the full scope of what that means, the Supreme Court hasn't had to get there. Why? Because they haven't had to bother. Because again, to be dangerous and unusual, you have to be both dangerous and unusual. And if something's in common use by Americans, it by definition cannot be unusual. And because it's not unusual, it cannot be dangerous and unusual, and therefore it cannot be banned. And the Supreme Court's only had to deal with issues involving things that are in common use, and there's no debate about it. And that includes, by the way, stun guns in Caetano, which is 200,000 possessed. So the good news is Judge O'Connor understood this, and he applied the law correctly. He went on to say that indeed, under the Second Amendment, these arms, specifically these pistols with pistol braces, are indeed protected arms, and they're in common use and cannot be banned. That is exactly what the judge said here. So he goes on to say, for example, that the court finds that Mr. Mock, Mr. Lewis, and other individual Firearms Policy Coalition members are threatened with irreparable injuries in the absence of an injunction. The threats to individual FPC members are twofold. One, sustaining permanent and unrecoverable costs from their compliance with an unlawfully issued regulation. And two, suffering impairment of their fundamental right to keep and bear arms for self-defense. Bang! So the first part about compliance with an unlawfully issued regulation speaks to, again, really the Administrative Procedure Act and the enabling statutes. But the second one specifically talks about the fundamental right to keep and bear arms for self-defense. And then he goes on to say that Mock and Lewis each lawfully possess at least one pistol with a stabilizing brace that he was acquired by lawful means before the regulation. And then it goes on to talk about, are these protected arms under the Second Amendment? And of course, he says they are. By the way, before I get back to the in common use, there's an interesting statement here in this opinion I want to bring to your attention because I'm not sure a lot of you are familiar with this. And I think this is sufficiently sort of newsworthy that you need to know about it. That is, there's an estimate here of the cost of complying with this NFA rule dealing with pistols with pistol braces. Specifically, this is what Judge Reed O'Connor said in his opinion on page 15. He says, the Firearms Policy Coalition members might attempt to immediately remove their braced pistols from the final rule's coverage by disassembling the barrels and installing long rifle barrels in their place. But according to the ATF's own analysis, this will cost an estimated $1,134 for an individual to complete. Wow. $1,134 for an individual to complete what the ATF, and this is the ATF's own data. This is the ATF's own estimates according to Judge O'Connor. So that's quite significant that this is not an inexpensive compliance cost, and that's why Judge O'Connor says you're going to suffer irreparable harm, especially if you go through and spend all this money, and it turns out that the regulation was unconstitutional to begin with. That is money you'll never be able to get back. So to carry on, what Judge O'Connor says, he talks about weapons in common use. He says that the Second Amendment prohibits government from infringing upon an individual right to keep and bear arms. We know that. He then goes on to say, this protects an individual's possession and use of weapons that are in common use at the present time, which is exactly right. It's about what's in common use today, not at the time of the founding. That is borderline frivolous, and the phrase borderline frivolous is not my language. That's actually from the U.S. Supreme Court in their various opinions. So then he goes on to say, a weapon is in common use rather than dangerous and unusual if it is commonly possessed by law-abiding citizens for lawful purposes today. The relevant inquiry under the standard is the current total number of a particular weapon that is in lawful possession, ownership, and circulation throughout the United States. Bang, absolutely correct. This is key, key, key. The issue in common use is its mere possession is the same as use. Do not let anti-gunners do what they're trying to do, which is say, well, you only use a gun if you're pulling the trigger in self-defense. No. In Heller, Bruin, they say that, and Catano, the mere possession of the arm is use. Merely possessing the gun on your nightstand is using the gun. Carrying your gun for self-defense, even if you don't pull it out of your pocket, is using the gun. That is the Supreme Court, not what the anti-gunners are trying to do. They're trying to redefine this to say, if you don't pull the trigger and shoot that gun in self-defense all the time, it's not in common use for self-defense. That is BS. Don't be duped. And Judge O'Connor here, I'm glad to say, got it right. It's about possession and not pulling the trigger. Keep in mind, neither Heller nor Bruin talks about how many times people pull a trigger in self-defense. They simply talk about possession of the gun. Likewise, in Caetano, when Justice Alito talks about the 200,000 stun guns, he's talking about possessing those stun guns, not how many times people got zapped with them. He didn't even talk about people getting zapped with stun guns. In fact, in Caetano, the woman, Jamie Caetano, used the stun gun simply by brandishing it at the ex-boyfriend by saying, don't come closer, I'm going to zap you with my stun gun. Even in Caetano, she didn't even pull the trigger, but that was viewed, of course, as using or possessing, which is the one and the same, an arm. Then Judge Reed goes on to say that the ATF's regulatory analysis concludes, this is the ATF, not me, ATF, that there are between 3 and 7 million and a 50 percentile estimate of 5 million braced pistols under the ownership of law-abiding individuals for lawful purposes throughout the United States. Obviously, this is far beyond in common use. Somewhere between 3 and 7 million people have these braces, these pistol braces, and obviously that satisfies the in common use test. So not only is it obviously an arm, but it's also in common use, which means it cannot be banned, cannot be restricted, and that is exactly what Judge O'Connor said. Judge O'Connor then goes on to add some additional things. He points out that the Firearms Policy Coalition members' proposed course of conduct also involves additional aspects of the Second Amendment because it involves making common, safety-improving modifications to otherwise lawfully bearable arms for the purposes of enhancing the performance of self-defense. He then goes on, of course, to say that the conduct of acquiring, attaching, and maintaining rearward attachments, such as stabilizing braces, serve to make the pistol more stable and thus more user-friendly or more user-accurate. And as the explained earlier, accuracy in turn promotes safety in the real-life exercise of armed self-defense. He then goes on to say that there's also, and this is quite interesting, he says that the Second Amendment's text has long incorporated the right of personal gunsmithing, the right of private individuals to modify or acquire modifications to lawfully bearable firearms so as to increase their accuracy and safety for a more effective exercise of self-defense. For example, in order to sustain themselves against large and well-supplied British military throughout the Revolutionary War, the Americans relied on gunsmiths, individuals with know-how from working on their own guns, and Americans who are willing to learn the art of arms manufacturing. The judge cites to Joseph Greenlee, a scholar, in an article in the looks like the St. Mary's Law Journal in 2022 about the American tradition of self-made arms. He goes on to say this is analogous to stabilizing braces, basically equating people that work with stabilizing braces and play with stabilizing braces in their pistols is analogous to gunsmithing, and talks about that in this opinion about how it's protected under the Second Amendment. So congratulations to all the plaintiffs in the case of Mock versus Garland, the Firearms Policy Coalition. Great job, and we'll keep tracking this case as it goes up to the Fifth Circuit, which is probably where it's going to go next. Okay, I hope you learned something today at the Four Boxes Diner. If you have not subscribed, please do so. Make sure you follow me on X at Four Boxes Diner. We appreciate your support, spreading the word about the Second Amendment across America, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.